information. So we're happy to have representatives, attorneys here from Frills and Wilson. They're going to be sharing with you about this most important thing. Please, 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 any questions that you have, I know they won't mind. They need you to ask those questions. I need you to have this information so that, this is about minding our business. Amen. And our money is our business. Amen. Amen. Even if it doesn't matter if you're married, single, your money is your business. And especially in this time period, we really got to mind our business. And so I want you to have this. I'm going to turn it over to Elder D. Campbell in a moment. She's going to lead you in prayer, and then she'll turn it over to the representative of Frills and Wilson. I need you all to do this for me. This session, we said this session will be about 2 hours long. It'll be however long you all need it to be. Don't rush or whatever case may be. But after the session is over, normally at 12 o'clock, we always have prayer. I'm going to ask, and prayer is always primarily for one thing in particular, and because we have a prayer focus, I'm going to ask you all to lead in prayer. I don't want the men to come in and interrupt, for your session. Pray. We always pray for worship on Sunday. We always pray that God will bless God's presence for salvation, transformation. I'm going to ask you all to do that, to lead. You all lead the prayer session for tomorrow's worship. But also, we're, of course, praying for persons who are impacted, affected through this government shutdown, those who are not getting checks, and those who now will not be getting SNAP benefits. As you heard me mention, and when I did the calling post message, I mentioned last Sunday as well, on Wednesday, I'm going to ask us to when we go to the store, bring items to the church that persons may need who are not getting those benefits. We're going to make sure that we minister to as many people as possible here in Macedonia. On yesterday, I did the calling post message. I also said if you don't purchase the items, even, what did I say? Gift cards. That's it. I can't think of the name. Gift cards. No more than $50 gift cards. It can be, if you want to give $100, I'll be doing that. But I'm going to do it in $10 increments. Walmart, $10 increments. That way, it may be somebody, it may be a single person with a child who may not need a $100 gift card, may just need a $50 gift card. Want to make sure that we be able to do that kind of thing. So please do that as you go to the store today. Pick up something, bring to the church for the next couple of weeks so that we can minister to persons who are in need. And if you know of someone who's in need, you come, get the bags, you take the food to them out of what we have here. Okay? So, again, I'm going to turn it over to Elder D. Campbell. She's going to lead you in prayer. Then she'll turn it over to the representatives of Frills and Wilson. Let's give God praise for them. They are turning to it. She's representing. Amen. God bless. I'll see you all tomorrow. God bless you.
Good morning. Good morning. Let's pray. Heavenly Father, we're so grateful to be here today, to get this opportunity to learn about money and the things that we need to know. God, I ask that you open our eyes and our spiritual ears so that we can hear what the Spirit is saying, and that we will be blessed by this service. And dear God, just thank you. You're so wonderful. You're so good, God. And we bless you on this day. In Jesus' name, amen.
Well, good morning, Macedonia, friends and family. It's so good to see you. Thank you all for inviting us, Frills and Wilson, to be with you this morning for this presentation. I have already been blessed in your presence, hearing your declaration. I love a strong declaration that you can call to your mind in times of trouble, right? That I'm grateful always. And what is it? What's the end of that part?
Already, every day, every situation.
Amen. And so these are the types of situations that we wanted you to be prepared. And we want to leave today with a well-rounded understanding of your planning needs, right? So that starts with knowing about your will, whether you need a trust, powers of attorney, healthcare directives, and all this good stuff that goes into being prepared in all of your situations. My name is Attorney Brianna Ritchie, and my colleagues will introduce themselves. And so we'll get started with our wills and trusts. And as we go through our program today, we'll have about a 15-minute break so you can stretch, kind of digest the information, take your notes, firm up what you've written down. And then we have one of our lovely paralegals here, Miss Onisha. Raise your hand, Miss Onisha. She's in our corner here. And if you, in those 15 minutes, we want you to go see get some details and information. And if you'd like to set up a consultation with us, you can schedule with her at that time. Okay, are we all ready to go?
Yes.
Amen.
Hello, good morning. I'm Alexa Calloway. How are y'all doing? Good. So it's so wonderful to see so many strong women here, women who are leading families, businesses, legacies, you know. So today we're talking about how to protect what you've worked through estate planning, not just for later, but for right now. So now I know when you hear estate planning, you might picture something more that's more designed for the wealthy. But I'm here to tell you that it's not about being wealthy. I'm here to tell you it's not about being elderly. I'm here to tell you that estate planning is really about love and it's about preparation, okay? It's something that we all know is coming. So it's better to be prepared so that we leave our family with clear instructions on how to address our wishes, okay? Why estate planning matters. Estate planning isn't about money, it's about peace of mind. So it ensures your wishes are followed and it avoids confusion and helps your family navigate one of the life's hardest moments with clarity. And before we dive in, I'm gonna have a little fun test right now to see what you guys know about estate planning, okay? So just raise your hand if it's true or false. So only the wealthy needs a trust. Is that true or false? That's correct. Every adult needs one, and it's not about wealth, it's about direction, okay? So having a will means your family avoids probate. That's also correct. In Georgia, all wills must go through probate. And I'll talk about that a little bit more detail on how, if you do have a will, how you can still prepare, even if it does have to go through probate. A trust avoids probate. That's correct. A trust is, as long as it's properly funded, can keep your estate private and it can avoid court. Estate planning is for the elderly. That's correct. It needs to be happening as soon as you think about it and you don't have it yet. It's something that you should probably get into the means because we don't never know when it's our time to go. And lastly, a will cannot be updated once it's signed. Also false. I recommend that you check it and review it every 5 years just to make sure that everything is as you wish at that time. Things tend to change. People tend to leave before. And so it's really good to check back and look at that. So, you know, if you already have a will in place, we can always update that for you and review it. So, see, you already know a lot more about estate planning than I thought. So this is going to be an easy presentation. So, I'm going to go into detail about what is a will. So a will is a written plan for what happens after you pass away. It names who receives your assets, who cares for your children, and who carries out your wishes. This person is typically called the executor. They also have other names, but nowadays, male or female, they're all executor. But here's the catch. In Georgia, every will must go through probate court, and that means it becomes public record and it can take several months to close. And the court will supervise how your estate is distributed. So it's important to know that the will can be the first step. It's the first step of every good estate plan. It is the simplest, it's the most affordable starting point, and especially if you have a minor or a child or a smaller estate, it's the best first step to take. So I want you to think about this. Think of your will as your voice. So after you're gone, it gives your loved ones direction and structure when they need it the most, okay? What is a trust? A trust works while you're alive. So you can move your property, bank accounts, investments into it. I like to think of a trust like as a shelter. So think about housing all of your assets into this shelter, and it keeps the public out. It's a private shelter, if you will. And when you pass away, well, while you're living, you are the initial trustee. So you're the one who is putting everything in. You're the one who's controlling everything. It's actually going to mirror your social security number. Is going to be the way to identify this trust. And when you pass away, your successor trustee, which you will name in that trust, will then step into your shoes and distribute everything as you are wish. It can basically operate similar to a will, or we can design it in a way that keeps your assets into the trust for a certain period of time. Some people would call that a legacy trust. So what a trust offers is privacy. It's, as I stated, it's not a public record. Speed, the assets transfer faster than probate court because they already should be named into your trust at the time of you putting it in your trust. It needs to be the name, the asset needs to be renamed, essentially. Control, you can decide when and how beneficiaries receive the funds. And protection, you can safeguard assets for minors, blended families, or special needs dependents. And when I say blended families, what I mean by that is, say for instance, you have stepchildren and your assets that you inherited, you want to keep in your family. Well, a will may not be the best course of action to do that, right? A trust would actually probably be better because at that point in time, you can state clearly that that piece of property is going directly to your family, and you can, it would pass to them as long as you keep it in the trust. With a will, it's based off of who your heirs and your beneficiaries are, who are going to receive things. So needless to say you go before your husband probably will be the one to have all your assets. Well, when he passes away, his children are going to be the ones who are inheriting. So if you had a property that was just yours, his children now have have the ability to receive that. And see, those are the things we don't really think about. So when to choose between a will and a trust? Let me ask you all this. When do you think you should choose between a will or a trust? I kind of already hinted at it. When? Now? Now is a good question. Yes, now is better to choose between a will and trust. Well, basically, as I stated, a will is good when you need to name a guardian, when you're starting off with a simple estate, so it's the starting point, basically, and you just want something clear, something that, is cost effective, that can just get all your wishes out there, and it can actually identify what things that you actually have. A lot of people's family members don't know what their parents have, or they don't know what they have. So it allows you to take time to review, have a family meeting with your family, see what assets are out there that you have inherited or that you have acquired, and let your family know so that they're aware, so that no one can come behind you and take from you for pennies, because that happens. And so a trust is right if you value privacy, because it's out of the public record, and you don't want it to have to go through court. Now, I'm going to talk a little bit more in detail about what I mean by that, about a properly funded trust, but I do want you to know that essentially a trust is, although it is more expensive up front, it does save a lot of steps, and it does allow your home to be protected and any other property that you might have. It's also, if you're financially able to fund and maintain the trust, it's probably the best option. And if you want your real estate, all their properties, your businesses that are maybe in other states, it's another way to also keep everything together, because so you don't have to go to another court. Yes. Yeah, sure.
All right, so let's say that it's not the house, right?
Okay.
Then my children go to their father. What do I need to do to make sure? Oh, okay. All right, so I have a home, and so if something happens to me, then what do I need to do to make sure if my children go with their father, well, when they would go with him, that they keep the house and he's not like over it?
Yeah, so that's actually something we'll get more into a little bit later in the presentation, but there are certain deeds that you can have. Say you have a will, right? And in your will, you state that you want your house to go to your child. That can be done, but the best way to probably do that is to get a transfer on death deed, which is essentially transferring the deed to your children. And this can be done prior to your death. It wouldn't kick into effect until after your death. And at that point in time, you already have your house deeded in your children's names. That's one way. The trust is the other way, which if you were to create a trust, you would already have your children as beneficiaries to receive that house after you've passed. So you would basically say in your trust, I would choose to distribute my house to my children outright. And it's essentially when you pass away, they would have your trust documents. They can take that and we'll redo your deed. So your deed will be in the name of your trust, but if they would like to take the trust and basically remove everything out of it, we could change the deed into their names, transferring it back into their names out of the trust. So basically, there's either the will or the trust can basically still make sure that your children receive their house.
Okay, just say if you pass and your children, but not old enough to handle stuff. What you got to do? Put somebody else's name on there, right?
Wait, say that one more time.
If you pass and the kids, they say
they're still minors.
Yes.
Mm-hmm. Right. So they wouldn't be able to inherit. Obviously, well, they can still inherit the property and still can be in their name. But yes, they would have to have somebody that is over them to, I guess, carry out
And still you have to
the
put on
benefits of
there
the house.
that they get the property when they get old enough.
Right. In your will, you need to make sure you would have a guardian in place to make sure that that person would be the one. But also the successor trustee, if you have a trust, would make sure that that person carries out your wishes as stated in the trust. So there will always be a person in charge, or should be in charge in your estate plan to carry out your wishes if your children are still children.
Similar question to what she asked about the house, right? What about other assets, so investment accounts and things of that nature? How do you set it up such that while I'm alive, it's mine and I can use it
Right.
through retirement to death? And then once something happens to me, now it rolls over to, I'm assuming, a trust, and then I can manage the disbursements to the children?
Well, you can actually put your investment account inside the trust while you're living. And I would actually advise you to do that so that it's properly funded with that account. And then while you're living, you're managing it, you can use it as if you're using it currently.
Okay.
Because it's you.
Right.
So think of your trust as you. There's no different, right?
Okay.
When you pass, whatever your wishes are for that money to, I guess, go to, you can, as I say, you can distribute it outright to whoever you would like, charities, family members, you would state that inside the trust. Or you could choose for it to stay in the trust and I guess dole out in certain percentages to make sure that, I guess, it doesn't get wasted.
So that's like the generational wealth concept, right? So it's
Correct.
there for my children's children's children.
Correct.
Got it.
And also they can add.
Okay. Thank you.
Silly question, but is there ever a time where it's appropriate to have a will and a trust, or is it just one or the other?
No, so actually it's both. As I was saying, will is always the first step. Say you don't want to. Right. So if you want to, say you're not ready to pull the trigger on the trust, it's a little bit more expensive, right, than a will. I advise that you start with the will. Please start with the will. And then from after that, you can, decide to do the trust, and it'll technically override your will, so to speak. But then once I do a trust, I also include a pour over will. And what that means is every asset that's not included in your trust is poured over into your will. So anything that's not captured in the trust will be captured in the will. And that's a way to make sure that your nothing gets left out. And yes, everything that is included in the will will have to go through probate, but the way that I state it in my trust, that I try to make that an informal process, that the court already is just aware that there's a trust, that the executor has the ability to carry out the wishes as clearly stated. So I advise both, yes. Any other questions? Go to the next. Okay, so the Georgia probate process. A lot of people tend to be afraid of, I guess, the slide is not updated. Let me see, I wanted to talk about it. No, it's not. Okay, I'll just talk about it. I wanted you guys to have more information about properly funding a trust because that's the key term. And a trust will go through probate if it's not properly funded. So I want you to think of a trust like a safe. It only protects what's actually inside of it. So to avoid probate, you must move your assets into your trust. And that means deeding real estate into the trust's name, retitling bank and investment accounts, just like what she asked, assigning ownership of personal property or businesses, and updating beneficiaries on life insurance or retirement accounts, okay? So if assets stay in your personal name, they still will go through probate, even if you have a trust. So funding is what makes the trust come alive. And here at Frills and Wilson, we always take care of that first initial step. As I was kind of like glossed over a little bit, if you have a home and you would like your home to go in your trust, we would get with our real estate department and actually get that deed taken care of. We would transfer your property into your trust by changing the name, retitling it into the name of the trust, and then getting it recorded. And I always tell people, once you do that, you will have to update your insurance company. That's very key because the names change, and I don't want them to ever use it as a means to not protect your property. So you would let your insurance company know that you're putting your property into the trust. And if you have a mortgage on that home, you also would need to check to make sure that it doesn't accelerate the mortgage as long as you're doing this. But typically, it's just you have to sign some forms. But you're still able to do that even if you do have a mortgage on that home. So it doesn't mean that it has to automatically be paid off.
You say name change, what do you mean? My name is on my deed, so when I put it in the trust, is it still my name on the deed? What changes?
So when I mean retitling the deed, what that means is, say you have your name and a part of the process of doing the trust, I'm going to ask you, what would you like your trust to be named? And that's the name that's going to be in all of your assets that you put into the trust. So if your trust is, what's your name? Jesse. Okay. So you can have Jesse Living Trust. So your house deed will now say the owner is Jesse Living Trust, which is still you, but it's a new name. Right. Well, as long as you change the beneficiary as your trust. So she was talking about life insurance. So if you want your life insurance to also be included, you would need to update the beneficiary into the trust. So the beneficiary would be, what's your name? Jesse. Okay, so Jesse Living Trust would then be the beneficiary of your life insurance.
Your property insurance, okay, why you got your,
Okay, your property insurance, okay, why, if you change it to your trust, will I still get the same, not insurance, property tax? Will I still get the same property tax being a vet now that the name changed?
Yes.
okay, so I still get the benefit?
Yes. And actually, there's a little catch with that. So if you get, what's the tax called? I'm losing track of my mind. But essentially, if you get the tax benefits from the county, Homestead exemption, yes, the homestead exemption will actually attach to your property, it'll be frozen. Because you're putting your house into the trust and it's as if you are living on. So whoever receives, as long as they keep it in the trust, whoever receives your property and they keep it in the trust, they still have your exemption. But you will need to, as soon as you get your new deed, you need to take it down to the office so that they are aware of, so you'll take your certificate of trust and you'll take the deed and you will go and apply for the exemption again.
Okay, not just homestead exemption, but the veterans, 100% disability. That exemption that does not pay us.
You don't pay tax, right?
Right.
Mhm.
That still would go to.
Right.
Oh, praise God.
Well, so our real estate, she's actually going to be next. She's going to go more into the deed conversation, but so the Georgia probate process, if you do tend to choose to get the will, or if you absentmindedly don't manage to fund your trust with all of your assets, you do have to go through the probate process, not you, but your family members. The will be filed in probate court, then an executor is appointed, and that's typically the person who's named in your will. And then the debts and taxes will be paid from your estate. And then at that time, the assets will be distributed as your wishes were in your will. And whatever is left over will fall into your estate. So it tends to take 6 to 12 months, but if you have heirs that need to be located and creditors that need to be located and identified, the process can be longer. So that kind of makes it a little timely.
So how long is it with the trust?
Oh,
If a person passed, how long is the process?
oh, automatic. You don't have a process. I'm sorry. Oh, she wants to ask it out loud.
I was just asking, you gave the example of the will, how long it would take, 6 to 12 months. I was just asking how long with the trust?
Oh, well, so the beauty of the trust is that you won't have to go through a probate process. So as your wishes are included in your trust, will how they will be carried out, except for the things that don't fall into the trust. It'll still have to go through the same probate process, 6 to 12 months.
I just want to go back to, you was mentioning about insurance. Okay, now, a person has their specific beneficiary with the insurance company, okay? But with your trust, they would name someone else as the, beneficiary. Does that override what the insurance company have?
So the insurance company has their own process, so they're only going to release the funds to who's named. So
Right, so.
your trust will kind of just be left out of it. That's what I mean. Like if you don't properly update your beneficiaries, it's going to fall out of the trust. It won't be included.
Right, okay. I just want clarification on that part. Thank you.
You're welcome. Oh, did you?
I have a question about the trust.
Just for clarification on what Ms. Rolette asked. So if you don't change it, it's gonna be the beneficiaries that you had listed, or you can make the trust the beneficiary for the life insurance. Is that?
Absolutely. That is it.
Will that override it?
Well, so if you have updated, she's saying in the event that you have updated your trust to include the beneficiary, like basically on both ends, the beneficiaries are updated, then it's going to follow the trust. But say you do not include it, so that was my understanding that was your question. That if you do not include in the event that you don't update your beneficiary.
Right, what I'm saying, okay, say for instance, on the insurance itself, it may have Mary Joan. However, when they do a trust, they may have Louise someone, okay? So would that trust override that insurance? What's on the beneficiary on that insurance?
No, because they won't.
I know, that's the
Right.
clarity that I wanted.
Right.
No, it shouldn't, it would not.
Right,
That's what I'm
only
saying.
because in that event, the insurance company is not aware of the trust.
Right.
So they wouldn't know to
To
release
do
the
that.
funds to
Exactly.
someone different, right?
Okay.
Right. Right. Well, in that event, you have beneficiaries. They're not gonna have to go through the probate court for whatever they're beneficiary on. It's in the event that you do not have any beneficiaries.
Okay, so just to clarify, so I have a trust. I don't include my life insurance policy through my military insurance, my military life insurance. My adult children are on my military life insurance policy, but I forgot, just made a mistake, whatever, not to include that policy inside my trust. Will my children have to go, my adult children have to go through probate court, even though none of them live in the state of Georgia? But I live out there, do they have to go to probate court in order to get a life insurance policy through my military insurance?
As long as they're beneficiaries, they're going to receive that, but your estate will still need to be probated with, in the sense of if anything else doesn't have beneficiaries.
Excuse me, if you only have a will, right here,
Oh. I'm like, who's that?
and you live in Georgia, but you have property in other states, would it still have to go through Georgia probate, or if you only have a will?
If you only have a will,
Mm-hmm.
and you're saying, and you have property outside.
Mm-hmm.
Well, I'm assuming that person would probably file where you're living. So everything that needs to be probated is going to be listed on, I guess, they're going to have to, when you have a document and you want to go to probate court, you're going to list all of your assets. So as far as to what I believe, it's okay that they can just probate through Georgia, but as far as other states, I can't really speak to if that's going to be okay, but I only do Georgia law. But I don't know if you know South Carolina. She said basically it depends on the other state's law if that's going to be okay. Okay, so I just wanted to touch on a little bit about protective estate planning, and that's basically estate planning from when you are alive. So when we think about estate planning, most of us immediately think about wills and what happens after we pass away. But for many families, especially those dealing with a parent who may be experiencing dementia or early memory loss, I have a lot of people that come to me about this. They're concerned because now their parent or their spouse is now starting to experience memory loss, and they want to make sure that their wishes are going to be carried out as before that occurs, because there could be a question of whether or not their will is valid because they weren't of sound mind. It's important that you get power of attorney before that occurs. So, but for many families, especially I already stated that. And so in those cases, I focus on what I call a protective estate plan. And that's a plan that's designed to protect decision-making, preserve stability, and prepare for long-term care. So every person showing signs of memory decline should have 3 key documents in place. And that's a durable power of attorney, which gives a person immediate authority to handle your finances and legal matters without the court. A Georgia Advanced Directive for Healthcare, which lets the loved ones make medical decisions and honors end-of-life wishes. And in Georgia, our living will, which is basically how you want to end your life if you want to be taken off the life support, is already included in the Advanced Healthcare Directive. And a HIPAA authorization, which allows your family to access medical records and talk to doctors. All of those 3 things I actually include in my package for the trust. So if you would like to get a trust with us, I'm going to have all those documents created for you, I will even go a step further in getting an agency form, which means that whoever you're naming to step into your shoes when you're incapacitated will also sign. So basically, completely eliminating you from having to go to court during such a stressful time. Say it again. Sorry.
Can you have power of attorney over someone's health stuff if they do have capacity?
Well, I mean, I don't know if you really would, but you can have a springing power of attorney, which means is immediately your power of attorney over them.
Okay.
Or you can have the one where it only comes into action if they're incapacitated.
Okay, thank you.
So preserving stability is revocable living trust becomes invaluable if capacity is lost. The successor trustee can pay bills, they can sell property, and they can manage everything privately. And sometimes we name a co-trustee so an adult child can help manage those things alongside the parent. Now, so basically what that's saying is the trust can also act as semi-power of attorney, even though technically it's not, but it can act as that in the sense that they can carry out and manage your bills and make sure that your house, if it had, taxes are paid up and everything. They all have the ability to do that through the trust being named as a co-trustee. We also recommend a letter of intent, which is a simple personal note describing care preferences, routines, medications, favorite activities. It's not legally binding, but it gives families guidance and peace of mind to know what you would like to take place if you are incapacitated. It's basically something like you, but on a piece of paper, just so, because people will assume what they believe you would want, and sometimes it's better just to list it out, and you don't have to wait till you're passed away in order for those wishes to be carried out. Lastly, for families concerned about nursing home costs, we may also look into creating an irrevocable Medicaid asset protection trust. It's a little bit, the explanation with irrevocable trusts, rabbit hole I don't really want to go down, but basically irrevocable trust is something that once you create that trust, it cannot be changed. So even though you're living and say something occurs, you would like to change it, you can't, because it's irrevocable. Medicaid requires you to do that in order to freeze your assets, so to speak, to allow you to receive benefits from the state to cover nursing home costs. I have done that a couple of times at Frills and Wilson, so if you are interested in getting more information about that, I'll be happy to assist you. A personal care agreement also allows a caregiving child to be fairly compensated and still meet the Medicaid eligibility rules. That's also included in the event that you, I guess, have to get put in a nursing home and you still have a child that needs to be cared for. And lastly, for the family home, tools like a life estate deed or a transfer on death deed can simplify ownership, and it also helps avoid probate, which I talked a little bit earlier in the presentation about that deed, but we'll have our next presenter will go into more detail, like I said, about the deeds. But the goal is simple: protect now, plan ahead, and prevent court involvement later. Because when memory fades, the best gift we can give our loved ones is clarity, dignity, and control. So how to get started? So you can schedule a consultation. You can actually schedule it here today. And then what you're gonna do is you're gonna go and gather your documents. And like I said, if you need to have a family planning meeting before then, I do have family members also attend those meetings sometimes as well, just to get everything out on the table. You can do that as well. You're gonna gather all your documents, then you're gonna come in, you're gonna see me, we're gonna sit down, we're gonna talk about who you choose to be your executor, who you choose to be your trustee, if you wouldn't trust, who you would choose to be your residual, to get anything that you have in your residual estate, who basically we'll walk through each little step to make sure that everything that you would like included is included. And then after I get all my notes done, I will go and draft your documents, and then we'll kind of go back and forth between me sending you the draft. You'll review it, see if there needs to be any corrections made, any revisions, or if you would like explanations on anything. I will explain that in email, and then when everything's good to go, I'll schedule you a time to come in and we'll walk through everything and we'll do the signing. So it's not a very quick process, but I do like to be very thorough in estate planning and make sure that everything's clear and that your wishes are properly carried out as you would like. And like I said, you should review all your estate planning documents every 3 to 5 years, just to make sure everything is the same. Go ahead.
I wanted to ask, I have a sister that's autistic, and so she doesn't speak. She needs 24-hour care. So my sister take care of her, but she doesn't have any document, no power of attorney or anything. So what would happen if something happened to either one of those? Would the state get involved with that, or?
Yes, the state would get involved because she doesn't have anybody speaking for her to ensure that she's properly cared for. I would actually advise your sister to actually go and formally get a power of attorney just in case there is a time that she does have to be hospitalized or anything, she would need someone to speak for her. So they would try to get that all handled through the hospital, but it'd be better if you already walk in with those documents so that you don't have to go through the struggle during a stressful time.
Just a question about the letter of intent care instructions. Is that something that has to be done through a lawyer's office, or can it be a notarized statement, or?
Yeah, it doesn't have to be done through a lawyer's office. I just advise people to just do that on their own, just to make sure that you have your wishes carried out on a piece of paper. And also, I advise you, if you don't have a black box, that you buy one, so that all your important documents can be put in there. If you don't have a safety deposit box, but just in case your house burns down, that all your documents are safe.
Would that be the same as a will? Could you just write that down and you have that notarized, would that still be legit?
So actually, that's a good question. In Georgia, you need 2 witnesses in order for the will to be valid. So it's not just a matter of it being notarized or in your signature. You're going to need 2 witnesses that are viewing you signing it to validate that will. Otherwise, it's invalid.
Will you set up a report for that?
Well, probate, yes. Will, when you think will, always think probate. But you can make sure that everything that all your assets have, I guess, a response to avoid the court from making that decision. So any asset that you have that has beneficiaries, you name your beneficiaries.
So what if the siblings, like with my sons, what if they agree on everything in their will they still need to go? They still need to go?
Yes. Oh, yes. So a lot of times in real estate, what happens, people think that they don't need to go through probate, but they want to sell the house. And so they try to sell the house and they realize, okay, the title's not clear because the property didn't properly transfer because it never got probated.
No, I'm not
So
talking.
so I'm saying that's when it would kick in. So everything might transfer as it needs to because you've updated all your beneficiaries and everything, and hopefully you don't have any creditors or debtors that want to come after you or your estate.
I don't have any property. I'm just talking about mainly assets, things like that. I don't have any property, so they still would need to do the probate.
Well, if you have no property,
Right.
You don't have to, but if it does come up that something does come either at creditors, debtors, or anything like that, they would still believe that you are living. They aren't aware. It hasn't been updated. So that's what I mean about like probating your estate. It pretty much is the stamp into the world that you're no longer here.
No property now. I'm planning on getting this.
Amen.
it comes to holographic wills, is it possible, when I was a child, what people would do, and I don't know whether this is illegal, but they would literally write everything down, put it in an envelope, mail it and address it, put everything that it was for, but it wasn't open until that person died. Is that legal?
So it doesn't make an official will, right? But you can use it as evidence of what that person wanted.
Gotcha.
And so you still go to court and as somebody saying, well, hey, I was the representative for the estate, and this is what Mama left me, this is what Mama said. And so the court can use that as evidence, but that is not making an official will.
Okay, thank you.
Right, and they still will basically go through the probate process without a will, because it's not a will.
So with the probate, do we have to go through a lawyer to do probate?
No, you can actually handle it yourself, but I do tend to lean, obviously, not just because I'm not a lawyer, but just so that you don't get into any issues or roadblocks, it is easier with an attorney guiding you.
Okay, hold on. Did you finish? Okay, I have a question. I may have two. Now, you said with the will in the state of Georgia, if that's the only thing, and you married, say I'm married and I got a will and my husband passed away, you said that it goes to, everything goes to his children?
If his will states that. If his will states that. That's true. If his will states that everything that he owned, say you've already passed away, and he inherited all of your assets. When his will says that his assets go to his children.
No. That's not what I mean. Okay, say that my husband died today, and everything should go to me, but you're saying that.
Well, it could go to you, right? It could.
And all we have
unless he has a will that states otherwise.
Okay. Because that was confusing, because I thought you said that even if there was a will, then the assets would legally be.
So, as Attorney Tamika Haynes just said, you would only get a third.
Who?
Right. See, this is why there's benefits in getting a trust for your own assets.
Step in, or they get a third if they are listed on the list. Help me understand, because
This is if you do not have a will, and the court is determining who gets what.
okay, so then the court will break it up into the spouse and
The children. You said that's what you have.
I think my question, I was hearing Sister Jordan, and you were saying something about if you have no will. That was going to be my question. If you are married and you have no will, if your spouse dies, are you automatically his beneficiary? Does that, if you have no will and you have a husband, you're not automatic?
Not necessarily automatic.
Okay. Well, how does that work? If he
there is a way that you can go to probate court and do a years to court petition, and basically you're asking the court to grant you as the spouse all of his assets.
Oh, okay.
But if he has children, they can't object.
But you have,
because he has no will.
His children are your children. So, yeah.
Well, if he has his own children.
Yeah.
Right. These are blended families.
Together.
Right. This is blended family situation that we're discussing. Are you talking about your own children?
Yes. If you're married, you and your husband, you have children. Those are the only children.
Right.
And he passes away, but he did not do a will.
They're still entitled.
They are entitled to everything.
No, they're not entitled to everything. No, not everything,
Okay.
but they are entitled to his estate.
It would be the wife and the children.
Correct.
Would be entitled to.
Correct.
Okay.
I have a question regarding trust. I understand you said that trusts are more expensive, and I know they're probably, not probably, I know they're handled on a one case. But how is it determined on the cost of trust? Is it the value of your assets or a
How many
percentage?
assets you have?
How many, it's not the value of it, but how many you have.
Correct.
Okay, thank you.
No, I'm talking about just homes, property, like your residence that you live in, if you have rental properties, or if you have a business, anything that involves need to do multiple steps, essentially, and also multiple deeds, that's gonna up your cost because I have to actually do the deeds. Oh.
On the statement with one of the spouses dying with no will and you have children, will you still have to take that through probate court in order to get it settled?
Yes. And he doesn't have a will, so it's also very problematic. So we should all make sure that our husbands have wills because, men, sometimes they need a little help. They need a little guidance. We have to be the ones to help them with that.
Could I ask just another question about the wheels? I had the same question you had, Reverend Baldwin, but just in gaining a little more understanding, once you pay for the establishment of the trust, is there like a monthly fee, so to speak, structure, or is there?
No.
I know you said
You
it
just
had to be
pay,
properly funded.
Yeah. So the properly funded part, I know you think funded, you think money, but funded just is another term it's a term of art, basically. It just means you're changing the name of the title of that property, basically. You're changing the name. And then properly funding is just a term of art. But as far as paying for the trust, you just pay us, and then we will do the first step of the initial funding. And then if you would like to put anything else in there, I have instructions that I would include in how you do that. Right. I will walk you through all of that, but I also will include funding instructions in your trust so that you don't have to come back to an attorney's office to fund anything else. Yes, that's a good question. Anything else? Yes.
So, what if you are, okay, so I'm an outside child with my father on my father's side. Okay, so, and then he passed away, but they didn't include me, and I'm not really, it never was really proven DNA testing or nothing like that, but we had a relationship. So, and he passed away, and I wasn't involved. They didn't put me, nothing. So, is there anything that?
Unfortunately, he never got legitimized, so you are not capable of inheriting anything. I'm also a family law attorney, so if you guys do have any family law needs, I can also assist with that. But yes, in your case, that's a legitimation issue. He didn't legitimize to become your legal father, so you are not able to inherit from him as if you were.
D.
My question is if, so a husband and wife come in and they do a will, can one of the parties change the will without the other person's permission? Is that permissible?
You each have your own will. You can do whatever you want on your will. It's not a joint will.
Oh, okay. She was saying if they had one together.
Yeah, if you had one together.
Oh, no. There's no joint will. Yes. Oh, she confused me. I'm sorry.
So my question is, ex-spouse have certain things that per military I'm required and entitled to. Former husband got remarried, does a trust. He passes away. How do I go about?
Well, I don't know if he put his military benefits in his trust. He didn't do that. Yes, it is a little bit more case by case analysis on that one, but generally speaking, it's going to be, you're going to have to look at your divorce documents actually.
Right. You know, to say what he wants to.
Well, if it's his ex-spouse, you would need to look at your divorce documents.
Right, so how is, that's.
I would have to look at your divorce documents just to make sure, yeah, before I could even answer that. Yes.
If you have PODs on all of your accounts, on all of your accounts, and you don't have any property, do you still suggest a trust or a will would be sufficient?
A will is sufficient.
Okay, say that you already have a trust in the will already. Okay, so you're married at the time that you did the will, but you're legally married in the state of Georgia. How do you go by separating him? If y'all been separated for years, he's the moved on, got a whole different family. Y'all been separated. So how would you go by taking him from off of your will or your trust?
You just do a new one? But that's why I said you need to review it every 3 to 5 years or any major life event like that, because yes, you would need to take him off because he would be.
So would you be able to take him off there even though that y'all are still married? Legally married in the state of Georgia?
You can take him off. It's
Okay.
your wishes.
Okay.
He doesn't have to have anything as your husband just because, I mean, you don't want to. He won't be there every now anyway.
In March, my children's father passed away.
I'm so sorry.
We were not married. My son went to stay with him as a 16-year-old, and of course he was 48 years old when his father passed. Of course, he was living in Arizona now, didn't live in Georgia. Had a house in Pennsylvania because he had moved there out of college. Of course, when he died, no one wanted to sign anything, do anything. He had 5 sisters, 6 brothers. Well, he was the 6th brother, so 5 sisters now, 5 brothers. My son signed for everything, got him back home, had a funeral. Once that happened, all of a sudden, they wanted to sue my son. Said that he had did.
Sue your son?
Yeah, because they said he had did things fraudulently, that everything should have gone to his mother and father because we were not married. They're even trying to say the child's not his now after all these years. It's like, oh my goodness. If you had any problems, why didn't you say something 45 years ago at least, something like that? So now they're going through a bunch of legal mess. If he had had no money, they wouldn't be going through anything, but because, of money, it's the love of it is the root of all evils.
Yes.
So the only thing he didn't have a will. I don't understand that. Educated man. He didn't have a will. The only thing that he had my son's name on was an old 401k thing from 1999. And so he had stocks, bonds, houses, stuff like that. So now they're bringing things up. My son still lives in Pennsylvania, by the way. And so
it's so much crazy legal stuff going on with the
I would
schools.
advise him to get an attorney.
Oh, he got an attorney once he went to Arizona
Yes.
to do everything, but now they're allowing that family to literally, they've frozen everything, done everything, and they're allowing that family, they've got to do DNA and all that stuff through the brothers and sisters. I'm like, really, y'all, come on. But
he didn't have a will.
But just by the fact that he had his son's name on the house in Pennsylvania and the 401 thing, that doesn't take care of anything, that doesn't say no, you recognize.
Well, it shows, as Attorney Brianna Ritchie stated, it does show intent. But it's also questionable. Like you said that you weren't married, so did he get legitimized? Well, that doesn't matter. So it might be a questionable thing with him not being legitimized and not being the legal father. They might have gotten his son a little, unfortunately.
I have a question. If you and your husband was married, but the only person named that's on the house was your husband, but he passed without a will, can the wife name just go on the house, or you got to go through probate for that too?
No, we can make a new deed.
Okay.
We do that actually here. So
Okay, just get a new deed. Okay.
yes.
Does that work for children? Same question. Mom passed away.
Yes.
Nobody's name's on the house. One of the kids, so if it's 3 children,
Did
one of
they
them,
inherit the property and
nothing happened. It's just there.
was a probate?
Nope.
Well,
It's just
it's
there.
gonna have to go through probate.
Got it.
Any other questions? Okay. Transfer on death deed. Yes. We do this. Okay, so estate planning I'm going to do my closing. Estate planning isn't about fear, it's about love, strength, and empowerment. It's about making sure your wishes are honored and your family is protected. Whether you start with a will or you create a trust, the most important step is simply starting. Which it sounds like today, a lot of you guys are more informed on the process. You know how and when you should start making these decisions. And I hope that you do decide to come and make those decisions with me. But thank you all for being here, for showing up for yourselves, for taking the time to learn and protect your family and your legacy. And because when women are informed, we don't build wealth, we build legacies. Thank you.
Let's give Attorney Alexa Calloway another hand, because that is a tough topic to talk about. When we're doing these questions, this is like an attorney pop quiz, and she has passed with flying colors. She did an awesome job, so we thank her so much. And I just wanted to say a couple things. Like, yes, there are some good legal words that are out there, and it does matter. Be prepared. Effective planning makes it easier to navigate. Because what the probate court does is they want to know what is going on with you, right? They want to know what happened to that property, where is it going, and what is happening. And so the way to avoid it or to navigate it easier is to have a plan in place, right? We're letting the court know this is what I wanted and this is what I wanted to do. When you have things in place like your pay on death accounts and your life insurance beneficiaries, you've let the court know I've taken care of it already. I don't need your hands in it, it's already done. All right, and so when you don't do that though, the legal term, when you don't have any plan in place and the court has to get in there and decide, it's called intestate succession. Say that with me. Intestate succession. And so there's a group of rules that Georgia has that says, okay, because you couldn't decide or you didn't make a plan, this is how I'm going to plan it for you. When we're talking about spouses they're entitled to a third, the children get the rest, right? Well, if I take 1/3, what's left? 2/3. Right, and so that gets split up, and it's all this math that goes on how it passes down because there isn't a plan in place, right? And then Georgia does have those special rules. Attorney Calloway mentioned the year support. If you're still married at that time, you can go to the court and say, hey, he didn't have a plan, he left me out here, or it works both ways, it's not just for women, but it gives you that protection and that extra boost. And then the last point that I think we heard, we talked about the concept of a joint will. It does exist, we do not do them. And we do not do them because if one spouse passes away and you say, oops, I want to change my mind, you can't. And so we absolutely do not do that. And so if you don't come to Frails and Wilson, I want you to know, if you go to another attorney and they say, yeah, do a joint will, run. And come back to Frails and Wilson, okay? All right, so at this time, we are going to take just a brief intermission. That way you can get your notes together, get your questions. Our next session is going to go more into depth about your planning as far as power of attorneys and getting your healthcare plans together, and more about those deeds. And so some of the concepts that were introduced in our first session, they'll be expounded on in our second session, okay? So if you will take a break, stretch, get something to drink, and this is also a time where you can meet with Ms. Diamond, get your name and number down. There were some consultations that I heard in the group, so make sure we get your information, okay? All right, and we will be back. Thank you. All right, ladies, I thank you so much for engaging with us. Thank you for your questions in between our breaks. Now we're getting ready to start our next session with attorney Tamika Haynes. She's going to talk to us about power of attorneys and all those good things to farm up your plan and what you can do with your deeds. Let's give her a hand and welcome her.
Good morning.
Lori, the clicker's not working.
So, like Ms. Ritchie just mentioned, we're going to talk about power of attorney, healthcare directives, and some real estate property issues that have come up. Okay, so what is a power of attorney? It's just a legal document that enables you to designate someone to act as your agent. You can have a broad, durable power of attorney where basically your power of attorney can do everything, or you can have a more limited power of attorney where your power of attorney can just do something specific. For example, you're buying a house, you're going to be out of town, you need someone to sign the document. So you can have a limited power of attorney or a broad power of attorney. Why do you need a power of attorney? In the event of incapacity, your agent will be able to handle all of your affairs. So you can make the power of attorney now while you have capacity. It will still be valid once you no longer have capacity, and that person will be able to handle all of your affairs. And you can also, in your power of attorney, designate a guardian should you ever need one to handle your medical affairs as well. So you can give your agent broad powers. Like I said, they can purchase and sell property. They can access your bank accounts, pay your bills, arrange for admission at a hospital, enter into contracts. They basically can do anything that you can do on your behalf. So to be valid, a power of attorney just has to be in writing, has to be signed in front of a notary, and you have to be competent at the time you execute it, but it doesn't have to be filed with the court or anything. And a POA remains in effect for as long as you direct it. So in the document, you can lay out how long you want it to be in effect and when it starts. So you can have a springing power of attorney that doesn't go into effect until you no longer have capacity. It can go into effect the minute you sign it. And you can limit its duration, like I said, to a specific time or event. Or if it's just a broad general power of attorney, it will be in effect until you die. It can become invalid though, so you can lay out that in the document. You can also revoke your power of attorney at any time. And then if a probate court ever appoints a guardian over you, the power of attorney would no longer be valid as well. And it's only good while you and the agent you designate are both alive. So once you die, it's no longer valid. So the advantages of a POA. It's pretty inexpensive. We can prepare it for you in our office. It's very easy. You can pick your own agent, decide what powers you want to give them. You can limit their powers, and it is durable. It remains in effect until you die, even if you're incompetent. So the disadvantages, some things you want to be concerned about. Your agent can abuse their power, so you want to pick someone you trust, someone who is not going to steal your money, someone you trust to do what you want them to do. And if your POA is kind of broad, there are certain companies that may not honor it. They have their own rules, so they want certain language in there. So just know that that could happen. So if you do not have a POA and you become incompetent in the future, someone, a relative of yours, will have to go through probate court and get guardianship over you in order to handle your affairs. So it's best to get a POA. You can avoid the whole guardianship process, which is much longer, much more expensive. The probate court would appoint this person over you to handle all your affairs. You'll have to get a doctor involved to verify you're incompetent. So it's a process you want to try to avoid by just making a POA today. There's also what we call a conservator who would handle your financial affairs. So the guardian handles your person, your body, medical decisions. Conservator would handle your finances, and you generally would have both people do it. One person do both, sorry. So just to summarize the difference between a POA and a guardianship. With a POA, you and the agent consent. You have to have capacity. It's just a simple document we can create for you today, very inexpensive. Versus a guardianship is when you no longer have capacity, so you can't consent. Doesn't matter what you really want. With a POA, you still have the ability to handle all of your affairs as well as your agent. Once a guardianship has been appointed, you can no longer take care of any of your own business because you don't have capacity anymore. And a guardianship has to go through probate court. A POA does not have to be filed or go through a court at all. Okay, so you want to get, in addition to a will, you want a POA. The other document you want to get is an advanced healthcare directive. This is just another document that we can draft in our office for you, where you lay out your medical preferences if you're ever terminal or unconscious and can't let the doctors know what your wishes are. So you would pick an agent that can make medical decisions for you, and you can also lay out your own wishes. To be valid, it needs to be witnessed by 2 people. You guys may know it as a living will, but it's called an advanced healthcare directive. So things you can lay out in your advanced healthcare directive, you have kind of 3 options. You can put in there that you want your life extended as long as possible. So the doctors would do everything. They would resuscitate you, give you medication, food, everything to extend your life. You can put in there that you want your natural death to occur. So they're not going to do anything. They're not going to give you any procedures or artificial nourishment. Your natural death would occur. Or you can there's a third option where you can pick and choose what you want the doctors to be able to do. You may want nutrition, but not CPR, for example. And then you can lay out many other medical preferences that you have in the document as well. So the person you list, if you're unconscious, they will be able to admit you, discharge you from the hospital, contract for medical services, consent to any treatment. They can also authorize autopsy, for example, organ donation if you want them. You can lay out what you want them to be able to do in the document. So when we think of estate planning, you want both or a will and trust, POA, and medical directive. And we have a package. If you come to our office, you can get all of those documents done together. So I'm going to kind of move on to like real estate issues that some of you have been bringing up. This is a very common question in our office. What are my rights if my name is not on the deed? So if your name's not on the deed, you generally have no rights to the property unless one of these 3 situations apply. So the owner passes away without a will and you're their heir, the property would be yours. Or the owner has a will and you're listed in the will as the beneficiary, then the property would be yours. Or you're married to the owner. We're going to go through all 3 of those. So if the owner does not have a will, we've kind of discussed this, but and has a spouse, the spouse would inherit the entire property. If there's spouse and children in Georgia, the spouse gets at least 1/3. If there's only one child, you each get a half. But if there's more children, the spouse would get 1/3, the children would split the other 2/3. If there's no spouse, then the children, how many ever children, would split the property equally. If you don't have a spouse or children, it would just go down the line to who your heirs are. So your parents, siblings, grandparents, aunts, uncles, first cousins, so on and so forth. If you do not have a will, that's who will inherit your property. And you can change this. You can give it to whoever you want with the will. So if the owner has a will, in the will they will list who gets the property, and that person will get it, essentially. You do have to go through the probate process, as we've talked about. And the executor will then deed the property over to you. So the last situation, if you're married to the owner, even if your name is not on the deed, if the property was purchased during the marriage, it'll probably be considered marital property. And in your divorce proceeding, the judge will determine who gets the property, essentially. So it'll be worked out in your divorce. So I want to talk about some ways you can own property. And this is something you want to think about, because this is another common issue that we get when people co-own property together. It ends in fighting, especially more than 2 people own property. You inherit property from your parents or grandparents, and now you got 5 or 6 people who own the property. So everybody is entitled to the entire parcel. Usually you have one person who lives there and the other people want their share or something. You're entitled to go move in as well. And nobody can do anything without consent of all the owners. We get so many people in our office, how can I get this property in my name? You really can't. There's no easy way to do it if they're not all gonna sign it over to you. Regardless if you're the only one who's lived there and you're paying all the taxes, it does not matter. They still own their portion of the property. And so you really can't do anything without their consent. For example, if you want to rent it out, you got to give them their share of the rent, even if you're doing all the work. If any owner gets a lien, it attaches to the property, it encumbers the entire property. Lien has to be paid before you can sell it. The only way to kind of resolve this, if everybody's not in agreement, is to do what we call a partition. Basically have to sue each other. And it's a very expensive, lengthy process, and the judge will order that the property is sold and the proceeds will be split, unless somebody can afford to buy everyone else out. You don't understand how many people come in our office talking about heirs property. So when you're doing your estate planning and making a will, I would think twice about leaving property to multiple people, because it's going to lead to issues down the road. The best thing to do if you have 5 or 6 people you want to get your property is to sell it and give them the proceeds. Do you have a question?
Okay, what if you have it's heir property and it was left to my mother and her siblings, and now almost all of them are dead, and now we got like one person living on. How does that work?
So everyone who's deceased, their kids would own a portion. So I'm not how you and all your cousins own the property. So it's just like I said, either one person should buy everyone out. Whoever lives there, if they can afford it, they should buy all of you out and you sign it over to that person. If there's no agreement, whoever wants their share of the money would have to sue everyone else. Now, you may have to do probates of all these people who died. It depends on how long they've been alive, but there may need to be probates done as well.
So if we're not kind of into that part, so if I decide to take and build something on there, I could do that on like, how did that work? Because my cousin got something on there. Nobody, it's just land now. Nobody else, just one person got something on there. So
it's a large parcel?
I can't remember how many acres. It's kind of big. Yeah, it's kind of big.
So depending on how big it is, it can be subdivided. So you can take a portion of the property if everyone would agree, and you can just cut off a portion of it, and then you would own just that portion, if there's agreement.
So with the buyout, one house divided between 3 siblings, does the buyout have to be a third of the value of the property? Or could we agree?
You can agree to whatever you want.
And that's the buyout.
Yes.
And they sign the paper, I write the check, their portion is now mine.
Correct.
Perfect.
They would need to sign a deed.
Got it.
We have property inside of, out of the state of Georgia or whatever. So since my mother's deceased right now, so her name is basically written off, but ours is still on there because we're basically her kids. It was left to the sisters when my grandma and grandpa passed. Okay, so we want to basically put something on that land, but the state of Louisiana is telling us that we can't because we were like, I guess because we're still young and the property tax is being paid, but they won't let us put actually nothing on that land. And why is that?
I mean, I can't speak to Louisiana law, and without knowing the details, if you own the property, your name is on the deed.
Yes.
That doesn't make sense to me. I don't know what the issue could be.
Okay. Okay.
Okay, when you say heir property, if you got siblings, children still living, could they do anything, or do it got to keep on going on down the line, like the grandchildren, great grandchildren, all the way down? Where do that stop at?
I'm not sure your question. So you want to get it resolved as soon as possible, because the longer you leave heir property and all these people's names are in a deceased person's name, the more owners you're going to get, because more and more people are going to die. It's going to lead to more and more problems.
I'm saying, well, all the children are not dead. Do they have the
Whose
same?
name is on the property?
My mother's name on the property, but she's deceased, and my father's name was on it. Both of them deceased, but they didn't leave no will. But it's 5 children still living.
Are some children deceased?
Yes.
So the 5 children plus the children of the deceased children would all own the property.
Okay.
Okay. So the alternative to owning property is tenants in common is to own property as joint tenants. You see this most commonly with married couples. So you have 2 people who own the property. The deed would say that upon the death of one of them, the property automatically goes to the other one. So doesn't have to be spouses, but that's where you see it. It can be any time more than one person own the property. You would do this, you can set this up when you're doing your estate planning. If you want your spouse to automatically get it, you don't want your children to get, because if your tenants in common and 2 people own the property, when you die, your spouse will only get their 1/3. And if you have children, your children would share the other 2/3 of your 1/2. So you can do joint tenants and your spouse will automatically get the entire property. And they don't have to go through probate or anything. Right, that's just the legal term, joint tenants with right of survivorship, that you're the owner, correct? So the third way that you can own property that we're going to talk about is a life estate. So with a life estate, you have the ability to live in the property during your life. And then when you die, it automatically passes to what we call the remainder. Whoever's listed in the deed is the remainder. And so as the life tenant, you just have to keep the property up, keep it in good repair. And this is another way to avoid probate, because upon your death, it will automatically go to those remainders. You see this commonly in blended families. For example, like you own a house that you bought before you got married. Now your new spouse has moved into it, but you have children and you want them to get the house, but you don't want to put your spouse out and not have they won't have anywhere to live. So you could leave your spouse a life estate, and then upon their death, it would automatically go to your children. And you can terminate a life estate. So if you inherit a life estate, you can just sign your rights away to it. If there's a large estate, sometimes people will take a buyout. So it's just like any other interest in property. It can be deeded away, transferred, etc. Okay. So go ahead.
About survivors deeds. I mean, if one person died and the other person's name is on there, I mean, it automatically goes to the other person, right? Okay.
That's correct. If it's a joint tenant with right of survivorship deed, that language has to be in the deed. Any other questions? Okay, just to kind of recap, when you're thinking about planning for your future, will and trust, POA, medical directive are important documents you want to get. And when you're transferring property, think very carefully about transferring it to multiple people. Think very carefully about what kind of deed you want to do. Any other questions? Okay, thank you guys.
For expounding on that knowledge and giving us some good things that we can really hold on to, and knowing about our property, right? Knowing how it gets split up, and to handle your affairs timely so it doesn't get out of control and get way down the line. So now you're sharing property with 64 cousins and don't have enough to buy everybody out, right? Awesome. So let's take one more of our breaks. We're getting a little bit closer to our time, but I want to make sure that you all have a chance to really sit on your questions and make sure that you've signed up with Miss Onisha. Has this been useful and helpful to everybody? Good. I'm glad. So we'll take that one more break, and then we've got just one last session, and we look forward to seeing you then. Right, the time is now 12 o'clock. We can go ahead and resume. Uh, I'll let everybody get a chance to get settled, and let's see if we're ready. Is it working? All right, thank you so much. It looks like we are ready to go. I've called myself being a little bit of an MC today. Have I done an okay job? Thank you. Well, surprise, I am also an attorney. I am not so expert in the probate and wills and trust world as they are, which I am so grateful to be able to work along people that can answer more questions than I can. But my area of expertise is in personal injury. And so that's, your attorneys on the billboards, call 999 to 999. It's my money, 99. All those people, that's me. And so, and I specifically do personal injury, and we're talking about car wrecks, slip and fall, nursing home negligence, and medical malpractice. So I'm looking for very specific things. And so when I heard about y'all's theme that we're minding our business, I said, well, you know what? Health is your business, right? And so that's for you and for others around you. So we're going to talk about today some things that I want y'all to be aware of. And while, we've talked about some estate planning and things that you can know ahead of time, you come to me when something unexpected happens, right? You come to me because something happened to you and you couldn't have planned for it, right? And so we're going to talk about some ways where you can, while you didn't plan for something to happen, you can be prepared, okay? And so if you don't hear anything else from me today, you'll know these 3 things I want you to take away. Number 1, seek treatment as needed. 2, I want to make sure that you completely document your condition. And then 3, we're going to follow up as suggested, and we'll talk more about what these 3 things mean. So first of all, you're going to go to your doctor's appointments, right? And there's things that you can do before getting there so that you're ready for your doctor's appointment. I know that it doesn't seem like something we need to do a lot for, but there are some things that you can do to help yourself be ready. And I'm sorry if it's a little difficult to see. I'll know next time to make it bigger because I can't see. But first, you're going to gather your medical history and your prescriptions. So when we're talking about your medical history and prescriptions, your doctor needs to know what you're already taking. You need to know what you're already taking. Because if you go to the doctor and say, well, I have high blood pressure, well, what are you taking? I don't know. That's not going to help your doctor know what to prescribe you. Has that medicine worked out for you? Is there something that we can do better? They're not going to know if you don't know. So make sure you have that list and you're able to let your doctor know what is going on with you. Okay? Next, if you do happen to have a visible injury, we're talking like scars, bruising, and things of that nature where it's on the outside and we can see it, take pictures. And the reason why I say take pictures is because it'll help you in the long run with tracking changes. So if that scar is getting bigger, if that mole is getting bigger, you won't know if you didn't know what it looked like in the beginning. So make sure that you're taking pictures and you're tracking your progress so that your doctor knows, is this getting better? Is this getting worse? Should we change our course of treatment? And the last thing to do before your visit is to contact a friend and get a friend or a family member to come with you. And this is for, of course, one, emotional support. Doctor's visits can be nerve-wracking. You know, you might get some bad news and you don't want to be in that room all by yourself if you can avoid it. The next thing is that person is going to be available for note-taking and remembering what happened. Because like I said, you're taking in this information from your doctor. It may be changing your whole world right now. I can't focus on what he's talking about. I don't know what he's telling me to do next. But my friend next to me, my sister knows. My sister is locked in and focused, and she's going to take those notes for me and make sure that I'm staying on top of it. So make sure you have somebody there. Now that you've prepared for your visit, what's happening during your visit? During your visit, you're describing your condition in as much detail as possible. What does that mean? My shoulder hurts. Okay, is it falling off? Is it is it itchy? Is it a stinging pain, a dull pain? How long has this been going on? And so you're going to describe to your doctor using dates whenever possible, and you're not going to exclude bad habits or embarrassing events. And I put quotations on there, embarrassing, because this is your doctor that you're talking to. This isn't somebody that's going to put it on the news. They're not going to, shout it from the rooftops that you had an accident in Walmart. But they need to know that information to know how to help you, right? Because they can't help you if they don't know, right? And so after you've talked about your condition, you've let them know what's going on with you, you say, hey, I need help with X, Y, Z. The doctor's taking in information and they may be prescribing you things, but you also need to ask questions, right? Because if the doctor is telling you something, well, I want you to take this medication. If you're not asking questions, well, what does that medication do? Now they've prescribed you something that you may not need because you didn't ask questions, okay? Make sure that you understand the terms being used, because sometimes big words are happening in that room. I don't need big words. I need to know what's going on in my body. I need you to explain it in a way that I understand and in a way that I can repeat it to another doctor. If I don't trust you, then I need to tell on you, right? So you need to know, ask those questions and get a good understanding of what's going on and get clarity for your next steps. This is going to matter. We're going to talk in just a second about why it's important to get that clarity. Because after your visit, what I want you to do is make sure that you access your medical records and review them. Because as an attorney, when I'm looking at your records and I'm preparing a case for you, I'm like, okay, well, what do they tell their doctor? If you went in there and said, well, doc, my arm is falling off, my leg is twisted this way, and the doctor only wrote down, she's in pain. What does that mean? Like, what happened in that room if my client told you all this long history and gave you good dates, and she listened to me after that seminar and she had her dates ready, her prescriptions ready, and all you wrote down was 2 sentences, she's in pain, she'll be all right in 10 days. I can't do anything with that. And so that's why, and especially in this age of technology, you can go online. You should have a portal available, and you'll be able to look at those notes that the doctor took. And if you go on there and it doesn't reflect what happened in that meeting, and especially if you took your friend, like I said, you ask your friend, well, friend, didn't I say that? Your friend says yes, then you and your friend need to go back to that hospital and say, hey, I looked at my records and it doesn't say what I told you, right? And after you check for that, you're also going to check and make sure that you have your prescriptions in line, that you know what referrals you'll have. And then after you get your prescriptions and referrals and you've made sure that it's accurate, you're going to go to your follow-up appointments that are suggested. And we'll have some examples on why that's important. But if you go to the emergency room and they look at you, they get you in stable condition and say, all right, I want you to see your primary care physician. Do you need to go see your primary physician? Yes or no? Yes. If they say, I want you to go to a specialist, do you need to go to that specialist? Absolutely. And you've got to do it in the time that they tell you, right? And then once they create this plan for you, you need to remain consistent with the treatment plan. I mean, things happen. Sometimes we forget our medicine some days. Sometimes we forget to keep things in line. But if you know your plan, you can get back into it, right? Because we want to make sure that we get better and stay in the best shape that we can for our families. So now that we know what to do before, during, and after our visits, I've got some examples where we're going to apply this information to the law. So like I said, I do personal injury, and one type of case is my car accident case. So we're going to talk about what happens if you're not consistent with your treatment. So the facts that I have here, a car accident happened in January. My client said, well, I've been suffering from headaches, back pain, and neck pain, but the accident happened in January. They didn't see anybody about their headaches and back pain and neck pain until August. How does that affect their case? It affects your case. And let me tell you why. Because if it's been how many months between January and August? Right, it affects your case poorly because what you're doing is you're losing the connection to the accident. Because now all these different things could have happened to you in 7 months that I can't, credibly go up to a jury and say, no, that headache was caused by the accident in January. Oh, what about that time you got bad sleep the night before? Which one is more likely to be the cause of your headache, right? And so we need to make sure that we're staying consistent with our treatment, following up immediately when the doctors tell us to, and keeping up with it so we don't have breaks in it. That way, when Brianna's ready to go to court, Brianna can say, my client did exactly what she was supposed to do. She's been hurting for 8 months, and she's been going to the doctor for 8 months, right? And that's how we get the money. So let's talk about our next kind of case. What happens if you do not do the suggested follow-up? So this is a medical malpractice, and in my type of law, a lot of people don't see me on their best day. These are some tragic cases. These are cases where everything that could have gone wrong went wrong, and sometimes I'm not always able to help. And this is part of why. So this particular client, and of course, no real names. Some of the facts are changed for, but so this particular person, they went to the emergency room for abdominal pain, constipation, rectal bleeding, and fatigue. Now, there's a couple different conditions that could have those same symptoms, but there's two very different types of things. One was diverticulitis, the other, cancer, right? And so the emergency room doctor, they diagnosed the diverticulitis, but they also suggested that they follow up with the primary care and get a colonoscopy to rule out the cancer. The patient did not follow up. A couple months go by. The symptoms are worse. He goes back in and he has stage 4 colon cancer. That could have been treated and avoided if he had gotten his follow-up appointment. And so how does that affect what Frales and Wilson and Attorney Ritchie can do for you? Well, I can't say that the ER doctor is liable for that cancer. I can't say, well, the ER doctor didn't get him the help that he needed right then and there. The ER doctor did what the ER doctor was supposed to do. He said, he said, go get the primary care, and it didn't happen. And so now we've got an unfortunate situation that we can't do anything about. Now let's, on the flip side, what are the effects of providing your medical history? So in this context, my client presented to the emergency room for pain in her chest, and she did tell the medical provider about her family history of cancer and that she herself had previously had cervical cancer. Right? She gave them all this good information. She told them exactly what they needed to know. Because of her chest pain, they did a CT scan, and it showed that there were masses in her chest. The ER doctor failed to tell her about those masses. They looked at it, didn't tell her about it, and then they did not tell her to follow up for cancer screening. Several months later, the patient developed stage 4 breast cancer. So what happens in this case? She did what she was supposed to do. She gave them the history. She asked for the test. Everything was supposed to be documented, but the doctor failed. So the doctor is liable for failing to tell the patient their status, and because she had provided her history, and the ER doctor should have recommended follow-up before the condition worsened. So it matters. Make sure that, and now, this case is a real case that's happening, and I'm able to go up against these doctors saying, well, hey, she did what she was supposed to do. You had the information, you failed to use it, that is malpractice, okay? So what does it mean in the context of our family and friends? So remember, in preparing for doctor's visits, you can prepare by bringing somebody, and this is how that helps. So this is a nursing home negligence case. This is somebody, the patient was an 87-year-old woman with a history of falls and dementia. Her family members had attended previous doctor's visits and could recite the relevant medical history to the nursing home. They told the nursing home all about mama's condition, what she likes to eat, don't put socks on her feet. They were able to say that because they were present and they were keeping up. But the nursing home, they had that information, but they did not monitor the patient or provide the equipment needed to make sure that she was safe. Because they did that, the patient was left unattended and broke her hip. So how does that affect it? How did the effect of having somebody in the room help? That made the nursing home liable for failing to provide the necessary safeguards as indicated by the family, and the family was able to advocate for additional treatment. And this was a successful lawsuit. We were able to get funds for this one because the family was there, the information was given, the doctors failed. All right? And so that brings us to our close. And so if nothing else, I want to make sure that if you're injured, or even before injury, if you're not feeling well, get the treatment. I know that medical costs are rising, but in the long run, ignoring it today doesn't make tomorrow better. Okay? So I want to make sure that it's completely documented. Make sure that your doctor is hearing you, that they're listening to you, and that they're writing everything down. Oh, yes, ma'am. Oh, can we get a mic? I want to make sure everybody hears.
The doctors now are recording you when you go in. They ask for permission to hear what your complaint is and what they tell you. I went to my primary care doctor for my annual. He did that. I had to go to the emergency room a few days ago. They did that. And I went to a specialist in Aiken, and he did it. So be sure when you go to your doctor, if they don't say, can I record that, you ask them, will you record this? So it'll be a backup. And they're also supposed to give you a printout of your visit when you see them.
Right, yes, and that is very important, and thank you for pointing that out. Oh, it can be recorded, but make sure when you go to see your records and when you pull that up that it was done, because they could have recorded it and threw it away, or put it on somebody's desk and it's never heard from again. So you need to make sure that that recording is documented down. We've got one in the back.
So, many people here in church know my story. I'm a 3-time cancer survivor, heart disease survivor. I had my 9th heart surgery in May. I'm in and out of the hospital often. Before cancer, only allergic to latex. After cancer, tons and tons of allergies, situationships. When I go to ERs, sometimes I tend to get treated poorly. When they look at my allergy list, it's immediately on the negative side. I don't have any family here, but my church family is my family, and many have offered to go to the doctors with me. So there's been instances where I've had to file reports through the nurse navigator, through the patient advocate, through the ethics department, and still waiting to even hear back. Sometimes the nurse navigator, patient advocate, really involved. They're immediately in my hospital room, contact me, and then after discharge, I hear nothing from nobody. I've sent reports, sent emails back, I've contacted them by phone, and nothing happens afterwards. What would be the next step to follow up on? And before I say this, I'm a very big advocate and preacher of telling other people, you have to be your own advocate. You have to know your own health, know your body, know when something doesn't feel right or seem right. You go get checked. You make sure you stay on them. You look at your documentation through the portal, through the paperwork, all of that to make sure that everything is right. And then if you don't see that, then you always get a second opinion. I've had been labeled as a extreme complicated case and get passed on to the next specialist that passed me on to a next specialist, and it just goes around. So for that situation, what would be your advice on my next steps when I don't hear back from these ethic directors, or these follow-ups just get basically swept underneath the rug?
So what I'll say is that, well, first off, it doesn't typically come to my office just yet because unfortunately the law is more reactive than proactive sometimes. And so what that means is that it's not much that I'd be able to do unless this lack of response and this runaround that you're getting results in an injury. Because what I need is somebody that did something that they weren't supposed to do, something bad happened to you because of it, and now I can recover because you did something wrong and something bad happened to me. So if I don't have those things, there's not much that the law is going to do about that. And so what it turns into is now you've got these two different actors that you can go through the chain. And so it's going to be different if your hospital is owned by the state versus if it's a private one. The private one is obviously going to be the harder one to report. And of course, if it's something owned by the state, then you would go through your state channels to get a state agency to respond on your behalf. Awesome. Okay.
I just want to make one comment about the recordings that you mentioned. Be careful with those. Those recordings are not for you. They are for the provider. Those recordings are used specifically to generate the note that goes in the medical record. So for you all, it's very, very important that you go out to your portal and you look at that note and make sure that that note is correct, because that's what stands in the court of law. It's what's written, not what's recorded. Also, they're not able to retain them after 30 days. They can't even access them anymore. So it becomes their word against yours, and their word is what was in the written note. So be very, very careful about those recordings. Now, if you want to record your own session when you're there, you can use that for you, but you can't depend on theirs.
That's exactly correct. Okay. All right, then my last, of course, take on that is follow up as suggested. Just because you take the first step doesn't mean to stop. Go through all the steps. Make sure that you've reached your destination and getting the care that you need until you're better. And if one doctor says no and you don't want to take that, you don't have to accept it. Or even with attorneys, if you don't agree with what a professional is saying, go to the next professional. We aren't the end all be all. We don't know every single thing. And it might just be the fact that you need a doctor that understands your condition better than the doctor that you went to, especially in these shops where you might go to like an urgent care or emergency room. They're not specializing in that area, right? We all know that they're just trying to patch you up and get you out, right? So that means that we have to follow up with your primary care. Your primary care is going to know more about you specifically. They're going to know your history. They're going to know, okay, well, I know Miss Mary has been on this same medication, then I need to send her to this specialist to change her medication, right? So make sure that you're doing your follow-up and you're going through all these steps to make sure that you are well, right? Mind your health, mind your business. Thank you. Is there anybody to turn over to? That is the conclusion of our presentation. We thank you so much for having us, for being ready with your questions, being so attentive and knowing what you need for your family, and being able to connect that with what's going on in your lives. Make sure that if you do have additional questions for us, sign up so we can get you in for a consultation. We love to help. Farrells and Wilson, we handle all kinds of things. We don't just do wills and trusts. We also handle things like divorce, child custody, and some defense work. but you let us know what you need and come see us. And if we don't handle it, we know somebody that does. All right. We're happy to connect you. All right. Thank you.